I come before your lordship seeking notice and some interim protection.
Lord, before my learned friend starts, Lord, petitioner's lawyers have served an advance copy on the office of the governor, Lord, in the morning today. But as a result, my lord, I was asked to assist your lordships, my lord. I have
Yes,
not
sir.
been able to even go through the petition. If it can be kept, my lord, tomorrow or day after, my lords, I may be able to effectively assist the court.
One minute. Let me see who are the parties, sir. 1 minute before.
Yes, sir. Number two is the secretary to the governor.
Now, state is represented by the AG. Then the governor
by the SG.
SG.
Because I'm served, my lord, that's why. Otherwise, I would not have been here. The petitioner has chosen to, my lord, serve an advance copy.
Yes, R3R. Huh? R4.
The complainants,
R5, R3, 4, 5 are the complainants.
Complainants. Now, let me just explain the matter.
Yes.
I just thought. The governor who has granted the sanction cannot have any interest immediately in your lordships not or granting me interim stay. The governor has passed an order. Your lordship is judging the validity of that. That, has grave consequences. I have no problem, however so much time my learned friend wants to look into it. The matter is coming tomorrow before the criminal court.
Tomorrow?
Yes. And I'll tell your lordship the whole conspectus. I have not even opened yet. My learned friend as copy or no copy, I think our extra generosity in giving him a copy does not become a ground for adjournment as far as the governor is concerned. We may not have served him a copy, we served him a copy. That doesn't mean he has a right to adjournment. Now, let me explain to your lordship what the issues are.
I never claimed it as a right.
No, that's all right. I'm not saying you have, but allow me to open. Your preemption is what I'm trying to preempt.
Yes.
Preemption is what I'm trying to prevent.
I may make one request before the learned senior counsel. I appear for the fifth respondent. We have entered KV.
It's all right.
That's all right.
We've also been served a copy just in the morning. But
no, if the matter is tomorrow before the concerned court.
No, we have not initiated any proceedings. That much I can say.
You have not initiated?
We have not initiated. We have lodged a complaint before the Superintendent of Police Lokayukta, but for that, no other proceedings. But our instance is there.
Let the senior counsel say something. Yes.
Let me just itemize. I'll try to be as brief, but still, it will take a little bit of time. Not too much. Not too much. There's one of the old Parkinson's law that work expands to fill the time available to do it. Just because the lordship happens to be freer on this afternoon, I'm not going to expand the work to fill the afternoon bills. That's not the intention.
On the lighter side, my lord, in the courts, the work expands to fill the, my lord, memo, which we ultimately sent, my lord.
Now, Melis.
Yes,
sir. There are serious constitutional issues. There are direct statutory issues.
Yes.
I'll just itemize them and then Melis deal with one by one, probably with the simpler statutory ones first. And then Melis just itemize also the constitutional ones. Melis, the matter raises far-reaching issues for the reason, number one. I'm only giving the issues, so I should see the... Melis, you have an elected government. The elected government has the mandate of the people. Anybody, I'm not saying these are those people. I'm not saying about them. I'm saying in theory, in jurisprudence, anybody on the street comes with a complaint. That complaint, Melis, is made decades and decades, let us say, assume, after an incident. A, inverted commas, friendly governor gives sanction. Before that friendly governor gives sanction, the government of the state, scrupulously taking away the chief executive of that state against whom the complaint is made. It is not a case where I, have a cabinet meeting where agenda item 1 I recuse and agenda item 2, 3, 4 I come in again. He doesn't attend the meeting at all. The cabinet collectively takes a decision and that order is worth seeing, not in length alone. Every possible legal and factual aspect is dealt with in 100 pages. Saying these are the reasons why this complaint is false, frivolous, vexatious, should not sanction, cannot and could not be granted in law by citing case law, etc. This is done after a purported show cause notice is issued by the governor on events ranging from 1992 to 2022. From
1992?
1992 to 2022. I'll just, I'm only oralizing. I'll tell you, it was a very shocking situation. The governor receives that 100-page order, if I may say so, or a decision of the cabinet. Clearly, he is bound because the cabinet decision binds him and it falls under no part of the accepted category of 163. The governor, in a short 2-page order, which is the impugned document, decides to decide only one point. Does not address any single reason why the sanction ought to be granted on the merits. Not a single word of the 100-page order. Namely, suppose the cabinet says sanction can't be granted for reason 1 to 50. You can say reason 1 is wrong because of so-and-so, reason 5 is wrong, reason 10, not every ground, but at least most of the grounds. He does not address a single ground. The only ground he addresses is that there is conflict of interest and gives a one para en masse blanket order saying the cabinet is the alter ego of the chief minister who's the accused. Not the accused yet, but the potential accused. That's all. So, the cabinet, on even a doctrine of necessity, cannot act after the chief minister does not come into the meeting on the day at all. There is a single agenda meeting and he's not present at all. He decides that alone. Now, assume you decide that. What you have decided is that the cabinet decision is not binding on me. That's what the governor is deciding, Malas. I hope I'm clear.
Yes.
He is not deciding why.
So, is that the observation in the order?
Yes.
Right.
I'm sorry. Back to this case for the last 5 paras. Only the 1 para was off the case.
Yes.
These 5 paras are on the case.
Yes.
Whatever I've said in the last 5 minutes is what the governor does in the order. He doesn't decide a single factual or legal issue. He decides one issue, that he is not bound by the advice of the cabinet because according to him, the cabinet is the alter ego of the chief minister, even though the chief minister did not come to the meeting at all. He then picks out this complaint out of at least 15 or 12 pending for some length of time, which he has not decided, not sanctioned, not dealt with, and grants sanction in this one, without a single reason as to why sanction ought to be given, notwithstanding the cogent 20 reasons given by the cabinet decision. So cabinet is not binding, let me assume in favor of the impugned order, if I may call it the impugned order. If the cabinet is not binding, you have to give reasons 1, 2, 3, 4 why the reasons sent by the cabinet are bad. Then we'll see. He doesn't give that. On that short ground, the order is bad. That is one part. The larger issue, of course, is that if you accept this principle, and your Lordship has fortunately in several Supreme Court and Karnataka High Court judgments not accepted it, saying the sanction is a serious matter, it is not casual, it is fully reviewable. But if you accept the principle the way it is activated, anybody here will file a complaint to me. I am the governor, and I have to have only some inclination. I call him a friendly governor. And he will then issue sanction, followed immediately by a clamor for removal and resignation of the chief minister, thereby nullifying the popular mandate. You don't need 356, You don't need any provision of the constitution. You don't need 163 to destabilize governments like this. This is a larger issue. Third issue. So first and main issue is he has not decided on that ground alone. He has not given a single reason why sanction, apart from saying, I'm not bound by the cabinet. Second reason is the larger federal issue. The third reasons are narrower, but I'll come to them first when I deal with detail. He grants a 17A purported approval. Purported. Now, Your Lordship, I'll come to them one by one. I'm not...
Yes, yes.
There are at least 2 conditions precedent to a 17A, which are on the face of it missing here. At least 2, if not more. Condition precedent 1 is that it has to be on an application of an investigating agency. Lordship will call him policeman. That is written in the section itself. I don't have to carry Scroll to Dhanbad. The second condition is that provided this is a police officer who complains, he then complains in respect of a decision taken or recommendation made by the public servant, namely the chief minister in this case. The chief minister, it is common ground, has taken no decision, made no recommendation. Not once. He has never touched the file.
No role? No role of the chief minister?
No role, no file noting, no recommendation, no decision, the matter never came to him. This happened mostly in other governments. 92 to 22. The allegation is that he's a beneficiary. The allegation is not that he's a decision maker. Now, 17A condition on that short second ground, there must be a stay. Well, at the moment, condition precedent. 17A, you pick up and read the text. Has a police officer applied to the governor? My learned friends have not yet donned the police uniform, the complainants here. They are private complainants. Second, can it be a complaint about, show the decision to the court, which is the decision taken by CM which you are assailing? Which is the recommendation made by him? This is that kind of category where Lordship knows 17A was made for when I write on the file some recommendation. And that goes through. There is nothing. That's point number 3, Malas. Point number 4 is, Malas, also the new Sanhita, Malas, the section 218 of the Sanhita.
197.
Yes, which is, Malas, the equivalent of our, absolutely, equivalent of our 197.
Yes.
Now, Malas, here there's another interesting mix-up completely. Also 197, also section 19 of the PC Act. Similar, Malas, situations. The mix-up is simply this, that you apply in your order 218, but, Malas, 218 must mandatorily, the Lordship has done enough, Malas, 197 cases, involve the nature of the offense and a specific offense. It has to say that this man has committed this offense qua him, namely section XYZ, the ingredients of which offense are these. And in this manner, the ingredient is satisfied.
All in discharge of official duty.
And most important, I'm very grateful, in discharge of official duty. Nothing. And these are admitted positions. That's the third ground your Lordship must stay this completely laconic, unreasoned order with no application of mind. The fourth reason, is natural justice. The show cause comes to me, referring, it is preceded by the Advocate General's opinion also. There is one separate, small, short opinion also by the Advocate General. But forget that. The show cause, which is 26 July 24, comes to me referring to only one of these complainants, Mr. Abraham, who is respondent number 3. The entire show cause is about one Mr. Abraham, respondent number 3. The final order passed by him after he receives the 100-page order of the cabinet is a 2-page order, final order that I'm not bound. In that, he dismisses the cabinet, grants sanction by adding a paragraph about the other 2 complainants about whom he has never show caused me. That's point number 5. He has never show caused me about Mr. 4 and 5 who are sitting here. Yet the impugned order relies upon, refers to, for the first time, about and to Mr. 4 and 5. And, Malads, the still larger issue, which you should need not go into today, is, Malads, Nabam Rebia, which says that you must, it gives, Malads, actually the operative para of Nabam Rebia is really sufficient. It's a constitution bench. It says they are the only 5 cases in which the governor can act without the aid and advice. It consolidates the law in that 155 para number. This clearly, I would say, admittedly doesn't fall under that. To which my learned friends rely upon a judgment of MP 20 years earlier, Madhya Pradesh police establishment case, which suggests that though 163 binds the governor, there may be other cases where there's a true conflict of interest. Now, there are 2 answers, 3 simple answers. The answer number 1, Nabam Rebia cites the earlier one and then summarizes. Your Lordship will follow the second one.
Yes.
Second, and even more importantly, Nabam Rebia copiously relies on Shamsher Singh, the 7-judge original judgment, which says presidents and governors are totally bound, in this case by 163 and not beyond. Thirdly, and most importantly, on that debate, Wallace, the MP establishment, it says that you may have exceptions beyond 163, where there is a case where he sits and becomes his own decision maker. Obviously, I mean, 163 will not say that your Lordship will not sit on a case which affects your Lordship. It would not, it's obvious we'll say there's a bias and a recusal. So that is the MP establishment case. But you cannot in one foul sentence of the pen say that the entire cabinet is superfluous because it is headed by the chief minister, and ultimately all the ministers enjoy ministership at the pleasure of the chief minister. That is, then there is no question of any doctrine of necessity, cabinet governance, etc. Now on these, let me go one by one. I've troubled your lordships enough on oralizing. Let me be more focused now. Let us make it simpler. I'll go with the simpler points first.
Where is the impugned order?
Yes. So I'll go with the simpler points first. First point would be 17A.
No. Where is the order?
No, on the impugned order. 41. I'm taking a lordship to the impugned order to make the 17A point. 41.
Yes.
Of the paper book. Though I want to start with 17A, may I just read the order relevant parts just for my lord's convenience. Decision 42, Malas.
42.
Starts at 41, 42. Yep. Decision of the competent authority under 17 capital A, my lord has got that?
Yes.
42. Now I will skip, Malas. Just note the top para, first line is petition from Abraham. Lordship may put R3 there. And para 2 below adds 2 more names. Just tick that para 02. I hope my lord has got
Where are the two? Para 2, yes.
These 2 names were Pradeep Kumar and Sneh Kumari Krishna.
All right.
Now your lordship will know these are 4 and 5. Complainants 4 and 5. R4 and 5, I'm sorry. Now just note, it is common ground that these 2 names are not in the show cause, which is at page 265. The show cause is 26/7/24 at 265. I can't show a negative. I don't need to show a negative. Admittedly, does not have these 2 names. It's 265.
Volume 2.
Volume 2, I'm grateful. I'm grateful. Please say volume 2. Please.
This is dated 26/7/24.
I'm grateful.
Yes.
And the man named is Mr. Abraham R3. Your lordship can't find a negative because it's not there. Yes. The other 2. Yes. Now come back to the document lordship we're reading at page 42. This Abraham Malad's complaint, which your lordship is reading just now at 265, he receives the complaint and the same day issues show cause. My lord, no single straw breaks the camel's back. Your lordship takes a holistic view. Your lordship sees everything in a holistic perspective. Legal malice is not that I will come and say, look, I have legal malice against you. Nobody says that. My lord infers legal malice by the overall conduct. So I come in, so look at the larger issue of federalism, of elected government or mandate. Anybody goes to a friendly governor, gives the complaint today, the friendly governor issues a show cause the same day. And 12, I made a separate point on discrimination, Article 14, arbitrariness. 12 major complaints are pending with him, where investigation is complete. But some blue-eyed boy, as far as this particular complaint is concerned, comes in and he acts on the same day. So how many times the lordship had a show cause the same day, There is no time limit for a show cause. He selectively plucks out this on the same day. But I'm going ahead of my own story. Let me go one by one. Since your lordship is on this is a natural justice point on para 2 of page 42. 42 is a natural justice point, para 2.
This is the show cause notice.
No, 265 is the show cause,
yes,
where only Abraham is there.
Yes.
Whereas the final order has 2 more complaints.
That is the second paragraph.
That's right. Without any show cause to be those 2 complaints. I have no idea who the complaints are.
Now you said contents of those complaints form a part of this order. Which are those paragraphs?
But this first para 2 itself.
That's it, sir.
That's it. Yes, because my lord is absolutely right. Because he doesn't decide any of the merits. He says, I grant sanction because I am not bound by the cabinet. One line. I'm going to show that in a minute.
Yes.
Give me a minute.
Yes.
1 second. And till date, you have passed a final order. I have not received these complaints.
Not received the complaints.
This 4 and 5, para 2, which my lord is reading and holding just now.
The show cause note is only
Abraham. This para 2 complaints, while I am arguing before your lordship, as I stand here, I have not received. Which have become part of the order of the Honorable Governor. Now let's kindly go further. Page 43. 43.
Yes.
43 millers can be ignored, the top part, because he's telling you when I received, etc. Come to para 4. He then notes only descriptively that the government of Karnataka has appointed a high-powered commission also. That is para 4. That has nothing to do with the decision-making process of the governor. No reason. Para 5 quotes the operative part of the resolution of the cabinet. It's a little unfortunate. I'll show one of the most detailed cabinet considerations ever which your lordships can come across.
The operative portion is quoted.
That's right. It's a insult to the cabinet to quote this.
No, it's a very, very detailed. My lord, I wish every state has such a brilliant cabinet which can write legal submissions, my lord, which are borrowed, I think.
So now, a laconic, unreasoned order of the governor is not blameworthy, but a detailed, legally reasoned order of the cabinet becomes blameworthy because it is reasoned and detailed.
And possibly
this is not, Alice in Wonderland.
Possibly not written in the cabinet.
The governor's order is unreasoned, laconic, with nothing. And that, my learned friend, supports. But he says a cabinet, elected cabinet of the state, and versus an unelected governor, whom I have no hesitation in calling a friendly governor, will write roughshod over a detailed reason because it's reasoned. Why? Because the reasons must have come from lawyers. Is it a crime to consult lawyers, Balas? This side of the bar would be unemployed, Balas. Now, come to 6. That is the implication of our learned friend's interruption is, Balas. Now 6. I have considered the decision of the cabinet. So I'm just showing what has he decided. He decided nothing. I have considered the decision of the cabinet and of the file in relation in hand. It is noticed said file, Siddaramaiah had asked the Chief Secretary to convene a meeting and to place the show cause and all other material before the cabinet. Accordingly, the cabinet notice was convened. This is also wrong. Cabinet was convened on a separate item agenda with nothing to do with the CM, but I leave that. I have also just see the page 45 is important. Above para 7.
I'm there.
I am also taken note of the fact that the said cabinet was not presided over by Siddaramaiah. That's again a bit of a half-truth. The day the meeting was held, Siddaramaiah didn't attend the meeting at all. There's no question of not presiding over, etc. or recusal. It's not recusal. He didn't attend the meeting at all. In the present case, the petitions have been filed seeking grant of sanction against Siddaramaiah. The resolution of 1/8, the cabinet, has been passed by the... Look at the reason. If this reasoning is correct, Malus, no collegial decision-making, be it the High Court, be it the cabinet, can Malus be safe. Look at this reasoning. The cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution, I have also independently examined the petitions. Not a single reason. And Manas, if your lordship were to say that the cabinet, chief minister appoints the cabinet, then Manas, are you rewriting does the constitution allow you any other system? You have to be elected and then you may be appointed. Therefore, the cabinet can't decide anything. The blanket en masse cabinet is disabled because you, the governor, issue a show cause on the same day. Now go further. And he says, I have independently examined the petitions. Let us see the result of that examination. I don't think he has advice of any lesser lawyers. Since the sanction is sought against the chief minister, the surrounding circumstances of placing the show cause notice before the cabinet and the decision advising me to withdraw would not inspire confidence to act on such advice. So he decides, I forget about the advice entire. This is the reasoning. Then Malas. The subject of binding of the advice, so only point he decides is this point. This is the only decision, para 9 according to me, which is Malas, and I am arguing the first point on the assumption that the governor is right in this, on the without prejudice assumption that he's right. I'm not conceding it. The subject of binding advice on discretionary power is well discussed in the case of Madhya Pradesh establishment. Again, Malas, your lordship knows Malas the Mahabharata story of Ashwathama Hatho. Half-truth is much more dangerous than a lie. It is right. This is a constitution bench. But Malas, would your lordship cite a 2004 bench without citing Navam Rebia, which is 2016, which deals with this fully? At least cite it. You reject it, distinguish it, do what you like with it. At least cite it. This is the application of mind, even on the issue of conflict of interest, which is deciding. He's not deciding the matter at all.
Nabam Rabia is...
Then, well, if on these facts and circumstances, the governor cannot act...
Nabam Rabia, possibly you're mistaken, Dr. Singhvi, you're cited wrong judgment. Nabam Rabia is 10th schedule. It has nothing to do with this.
Which one?
Nabam Rabia is on 10th schedule.
I would
request... Defections,
anti-defections... can't do a distinction of a judgment I'm citing in mid-argument, Wallace.
No, I'm saying you committed an error.
It's only a clarification.
Allow me to commit my fundamental right to commit errors, sir. I will show who's committing an error.
Clarification.
I have a fundamental right to commit an error. I will show you 12 paragraphs of Nabam Rabia which deals with MP establishment. Then we'll find out what the error is. 12 paragraphs. And the learned governor, advised by the best lawyers, doesn't have this, Wallace.
The learned SG was wanting to clarify, that's all.
Now, Wallace, it seems to me that there are two... So, Wallace, this is the one para. Well, I have not responded once. When he interrupts me, Wallace, I'll have to respond. It's better he doesn't interrupt me. Then, Wallace, 11. In view of the above facts and circumstances, I am satisfied that sanction can be accorded. Now, Malad, this
9 you were reading.
Yes. So, 9, Malad,
if on the facts
it's just that Madhya Pradesh quoted.
After Madhya Pradesh, there is...
10.
No.
Oh, I'm reading the quotation. Okay, right, very well. I thought your lordship is... If on these facts, this is the quotation, Malad.
Oh, this is quotation. Yes, para 10.
Then 10, Malad. This is from that judgment without citing Nabam Rabia. Upon perusal, along with the materials in the petition and subsequent reply and the advice, it seems to me that there are two versions, same set of facts. It is very necessary that a neutral, objective and non-partisan investigation should be conducted. I am a prima facie satisfied. Where is the reason? Whereas reasons are said to be the process of ratiocination, which link the material with the conclusion. This is the conclusion. There is no reason here. Then, in view of the above fact, I am satisfied that sanction can be accorded against Siddaramaiah as mentioned in the petitions. Now my lord gets the again natural justice answer. Ibrahim, Pradeep and Krishna. Hence I accord sanction, mark the next line, under 17A. So, Malas, there are two ways. One is, this sanction, let us assume, decides one point. I'm not conceding anything. Please appreciate what I'm saying. I'm making it simple for today, Manas. He decides only and only, let me assume that my learned friend is right about MP establishment. I'm not going into it. It only decides that the governor can, in some cases, decide matters not listed in 163 and is therefore not bound by the cabinet. So I, for a minute, without prejudice, accept that. I don't concede it at all. I accept that he can treat the cabinet as rubbish and say, I'm not bound by the cabinet. Even then, he has to give a lordship a reason why he's granting sanction. Where is that reason is my question to myself. I find no answer. The governor's impugned order is eloquently silent about a single reason as to why sanction ought to be granted on the facts, on the merits, on the issues, on the reasons, etc., etc. And that is sufficient to quash it actually. Now just see two judgments on the governor's sanction issue. Directly if a lordship and both I think have a Karnataka connection, at least one of them does. Kindly come to us.
Copies are given?
Yes. The first one is Mansukha, 1997. Give it to the other side also once. Just give one first to him.
Abhishek, can you please repeat the citation?
Yes.
1997, you said.
Volume 7, SCC 622.
Thank you.
What is this?
97, 7.
Now in this, fellas, note 3 paras, 14. This is on the sanction. You are the governor giving sanction. How the sanction is to be looked at. Para 14.
Yes. At page 262.
Of the you give some other compilation to him or something. Sorry.
Does it begin with as has been mentioned above?
Oh, I see. There's also a different citation given. You give me something else and you give me some other citation. Yes, this is a different citation. This is SCC online.
Oh, it's SCC or Manupatra?
Open para 12. Just show me the judgment now. Yes, I'm very sorry, but this is the problem. Page number 225.
Justice Sagir Ahmad's judgment, right?
Yes, ma'am.
Yes. From a perusal of section 6, does it begin that way? Yes, Mansuklal Vittal Das Chavan. Yes, this.
Para 12.
Not done anything about.
Once a person against whom.
against whom. Yes, that's my copy starts with that, my lord. It's SCC. Possibly Dr. Singhvi has the SCC online copy.
Para 14. Para 14. Next page. Para
I think, sir, you're referring to para 14.
17. Correct. 14.
Possibly Dr. Singhvi has SCC
Same
online.
copies are given. What is this?
But online has some paragraph difference.
And I see here some Manupatra judgments are there, some SCC. What is this?
Give me a minute. You don't even have the judgment in your hand. What are you showing me the index for? Take out the judgment. I'm very sorry.
No, this, what you say, I think is at para 14, sir.
Abhishek, you possibly have, Abhishek, you have SCC online. Paras differ in SCC online and SCC print.
I'm trying to find the corresponding para for my lord.
It starts from where? I'll help you. It starts from what? Your para starts from where?
Well, my para reads like this. From a perusal of section.
That is para 14, sir. Para 14.
That is para 14 of SCC.
Page 262.
The one which my lord has got that para 14.
I have this para. From a perusal of section 6.
That is para 14 of SCC printed version.
So can you want a copy of
something? What are you doing? Even what you've given him and what you've given him is different.
No, it's better if same copies are there.
From a perusal of section 6, it would appear that the central or state government or any other authority, depending upon the category of the public servant, has the right to consider the facts of each case and to decide whether the public servant is to be prosecuted or not. Since the section clearly prohibits the court from taking cognizance, etc. Leave this one. Now come to 17. Now look at the next one. Don't justify this. Forget this. Sanction lifts the bar for prosecution. The grant of sanction is not an idle formality or an acrimonious exercise, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecutions. Muhammad Iqbal Ahmed. Sanction is a weapon to ensure discouragement of frivolous and vexatious prosecution and is a safeguard for the innocent but not a shield for the guilty. 18. The validity would therefore depend upon the material placed before the sanctioning authority. Mark the word material placed.
Yes.
And the fact that all the relevant facts, material and evidence have been considered. And the fact that all relevant facts, material and evidence have been considered by the sanctioning authority. Consideration implies application of mind. The order of sanction must ex facie disclose that the sanctioning authority had considered the evidence and other
One clarification. We have not yet gone to the stage of sanction. In the sense, the case is not advanced to the stage of sanction. 17A is mere approval.
No, 17A is so that's a,
no. The whole problem is 17A is mere approval, but what is quoted in the order is 218 also.
A. B. 17A itself. The point I'm coming to is you can't do it without two conditions precedent.
That's what.
So yes. But kindly see the problem. Your lordship is absolutely right. You adopt a pre-sanction stage in a technical sense. Then you violate even that pre-sanction stage 17A because there is no police officer, there is no recommendation or decision by me. And then actually while writing it, you bring in 218 also. Then where do I go? Tomorrow, can I argue this before the criminal court? I have to tell the writ court, where is the reason for all this? My lord is absolutely right. It's a completely jumbled up order.
No. In the sense, what you're now referring to is sanction. Sanction is akin to section 19 of the PC Act. But 17A is approval for inquiry or investigation.
But I'm saying, the principle I'm in here is not on sanction alone. I'm on application of mind. That's all. I'm only on 17 on application of mind. two sentences. One, he must have all the material placed before him. Two, he must, this para says, must show application of mind to that material. What your lordship has, not what I may be thinking elsewhere. Then, just to end this, 18 I've done, 19. Again, fourth line, it necessarily follows that the sanctioning authority, it may not be technically sanctioning, it may be 17A authority, any authority.
No, then 17A was not in the statute book. So
also only 19 was there.
I'm grateful. Has to apply its own independent mind for generation of genuine satisfaction. Kindly see the next.
Yes.
19, fourth line.
Yes.
It necessarily follows the sanctioning authority has to apply its own independent mind for the generation of genuine satisfaction whether prosecution has to be sanctioned or not. The mind of the sanctioning authority should not be under pressure from any quarter, nor should external. Absolutely, its discretion should be shown to or not have been affected, etc. Now, this must reflect from the order. I may be wrong or I may be right. I have placed the order as it is read. I can't add to the order. The order decides one thing and I'm for a minute conceding it. I'm not accepting it, I'm conceding it. It says, your cabinet decision is not binding on me. And the reason I give is, CM and cabinet is the same, and MP establishment. QED. I accept that for a minute. My question to myself is, where has the rest of the decision gone? Then, the same thing is Yedurappa. There has been rich contribution to jurisprudence, by that name also. There are many judgments. This one, is a judgment at 858. I hope the pages match this time.
858.
Yes. This is the division bench of Karnataka, which holds the field. There is no contrary thing in the in the Supreme Court, etc. And your lordship will just give me a minute. In this, come to para 22 onwards. Leave it. Look at this, verse 22. And look at the considerations rightly taken by them. Having heard the learned counsel for the parties and perusal of the record, we are of the opinion that as the complaint was a private person, a private complaint, great care, caution, and proper application of mind were necessary.
Yes.
Particularly having regard to the uneasy relationship between the then Chief Minister and the then Governor.
Yes.
If a crime was registered, followed by investigation for collection of evidence, both oral and documentary, the Governor could have in the hands materials for application of mind. The investigation agency could also have recorded the statement of the accused, as the allegation was of acquisition of assets disproportionate. Then, 23, we will skip. 24 is 197.
Yes.
Now, 218, etc. Do not lead to needless or vexatious prosecution. This is the larger issue. Is if you accept the principle, then no elected government can be safe. Then, assuming for the sake of argument, the public servant is acted in excess of his duties, but there is reasonable connection between the act and the performance, the excess will not be sufficient ground. Then, they give the history, 25, 26, etc. And come to 28. We know our limitations in considering the writ, but we are not concerned. We are concerned with the decision-making process. We have carefully gone through the order of sanction. With respect, the Governor has quoted the complaint in detail in his order of sanction. Virtually, there is no finding as to why he has accorded sanction in favor of the prosecution. There is no discussion.
He is reading from the written.
And then, the judgment cited against me itself is cited and applied rightly in my favor. The Governor cites this judgment, same judgment. Held that there could be matters where the Governor could act in his discretion even though the Constitution not expressly so provided. The Governor was therefore free to differ from his counsel. That also was not when the Chief Minister is nowhere near the decision making. In this case, he is nowhere near decision making. But I leave that. But no reason was mentioned as to why he was not accepting the opinion. No reason. There was also no reference to the said letter dated 19th or the order of sanction. Such relevant considerations are absent in the mind of the Governor. Now, I want to come to 17A, but after this 5 minutes, it's a very detailed order. I will do speed reading and not take more than 3 minutes on this. Your Lordship will see this order. is a single fact addressed by your lordship's governor in this matter. Kindly see. Is a single fact. Law. Come to that order, at page 336. It's very long, detailed, but everything is considered. If that is my learned friend's best point of objection, that it is very detailed and reasoned, then so be it. I plead guilty to the charge of detailed and reasoned orders. And reasoned orders and detailed orders, charged as guilty. Or guilty as charged, I'd say. Guilty as charged. Now see,
Yes. 336.
336 it starts.
Yes.
The cabinet meeting was presided over by so-and-so, Deputy CM. Then it continues right at the bottom. Legal opinion of Advocate General. Now leave that. I'm going to do some speed reading. Your Lordship is not concerned with the merits, but I must give your Lordship a flavor. This is very unfortunate. 338. 163 is discussed. From Samsher Singh. Everybody knows that the fountainhead of this jurisprudence, Samsher Singh, 7 judges. This is the fountainhead in the early 70s. And it says for president separately, for governor separately, and come to 339 in Samsher Singh. Well, in fact, your Lordship, I don't have the time today. The final hearing note will give that. And when matter came to Constituent Assembly, a very interesting exchange in 3 pages. I just digress for 1 minute. Lordship will be interested. Dr. Ambedkar was pressed by many members that you must have an elected governor. And you must have some powers to governor beyond 163. He gave a very nice reply. He says there cannot be 2 swords in one scabbard. On the contrary, we are going to nominate a governor. And I expect that very few people will be ready to take up the post of governor. Because the power must lie with the elected CM. There can't be 2 swords in one scabbard. Ek myan mein do talwar nahi, as they say. Now, see that sentiment from Samsher Singh. Under the cabinet system of government is embodied in our constitution. The governor is constitutional formal head. All his powers and functions conferred, etc. are in spheres. So while they give the whole of Samsher Singh rightly. And Samsher Singh is dispositive because it is 7 judges. It's the fountainhead. Then they cite 20-year-old MP Special Police Establishment. 20 years old at page 340. Then they cite a series of cases starting at 341 bottom. Gujarat Mehta is one case, And page 342, para 68, some portions are bold-faced in 342 and 343. These bold-faced portions are important. This is all the cabinet, considering it. But I'm going to come to the facts, which are very interesting in the cabinet. Then Yedurappa, the one I just read to your Lordship, is the 344 bottom. Where is any of this addressed by the governor? Your Lordship, he can reject it. He can accept it with reasons. Where is it? It's not addressed. So 344 bottom is important. Yedurappa cited. Then now come to 346. 346, where the factual matrix starts. 3 pages here, I must shorten it by just giving Lordship one part of the factual matrix. I am totally against your Lordship looking into it. Nobody is asking you to. But your Lordship should know what has happened. If your Lordship will note 5 dates for us.
Yes.
I'm giving your Lordship not actual list of dates, a broad dates. September 1992, there is a land acquisition notification, which is denotified in June 98. So 92, then 98. In 2004, there is a sale deed in favor of my brother-in-law. It's a sale deed. It's not some agreement to sell.
After denotification.
So 6 years later, denotification. 6 further years later, purchase. So it's 12 years from the beginning. Then there is conversion of land in 2005 for various activities, residential, etc. in 2005. In 2010, my brother-in-law gifts it to his sister, that is my wife. In 2010, there is no issue on gift being bad, etc. The actual brother and sister. That's not the issue here. Each is 3-4 years apart. Nothing has got this present Chief Minister involved in any manner. He was not in power even in many of these dates. At all. 2014, an application for compensation is made. So now your Lordship has reached 4-year gap again. Why, because somewhere in 2012 or 13 it is found, this is missing in the sequence I'm giving, that though denotified, the government cut out plots and acted on the plots. It happens sometimes. The Lordship knows sometimes in non-acquired land, the government acts on it, builds a wall, takes it over, gives it to these 100 people, creates equities. So, Malas, in such matters, even your Lordship does it many times, that you can't reverse the acquisition.
Compensation.
You give compensation, cash or kind. It's a very normal thing. 100 of the judgment do it. So that application is invited by the government and made in 2014 by my wife, who is the sister of the donor. She is the donee. In 2020, everything is 5 years later. There's no hurry, there's no urgency, nothing. Not like the governor who gets a complaint today and issues a show cause same day. In 2020, a resolution is passed saying, obviously your land is acquired, you have to have compensation. But we will give you, as we are giving hundreds of other people, half of the developed land. So 1/4 effectively is the compensation you will get. So Manoj, this is the land used wrongly. First take half of it, then half of that half, developed portion will be given to you, which is what is given to me in 2020. And a sale deed is executed in 2022 in lieu of as compensation was given to me. Now, just Your Lordship has got the whole facts. In 2024, along come these complainants, fellows, and they select one public servant out of Manoj's 32 years from 92 till today, who did denotification, who allotted, who invited compensation, who gave compensation, not to me, to hundreds of others. But those 100 of other beneficiaries apart, there must be tens of officers of government who are public servants. This private complaint is born when I am Chief Minister on events starting 30 years ago, where only one public servant, the Chief Minister. It reeks of legal balance. On the same day the governor will issue notice, fellows. Who do I come to, fellows? I can only go to the High Court because there's a friendly governor and the constitution has been upturned, fellows, completely. Now, on these facts, kindly continue. Come to fellows, page 347. I am saying this is all discussed by the cabinet. You don't even, fellows, treat the cabinet worth looking at. So, my lord, is at 351. Sorry, 346 is a factual matrix. Skip all that, fellows, and come to 351. My lord has got it?
Yes, yes, I am there.
I am doing speed reading, one para only. I'm not
No
reading.
problem.
It is evident from the record that the ownership was changed from so-and-so to so-and-so to Malika Arjun Swami. He's my brother-in-law. All this is happening at a snail's pace over years. Then 355. I'm not hiding anything. Anything I can, when I want to read, I can read. But I'm just narrating. Just 355. 355. The government of Karnataka makes a single member inquiry commission under the Inquiry Commission Act on 14/7/2024.
Justice P.N. Desai.
That's right.
Yes.
To look into it, very well, it's something or the other. They'll report. It's not the end of the matter. Then turn the page, Malas, the extracts of the terms of reference are given. Then come to 356. Action has already been initiated. The letters addressed by the Honorable Governor of 5/7 and 15/7 are annexed. A detailed reply. So the governor asked, what are you doing about the so-called MUDA scam? The reply is given, the Commission of Inquiry looking into it. So the governor gets the response about good governance, which the elected government thinks fit. Then all those letters are given in para 5.35. Now come to the complainant's part at 357, come relevant to 358. Para 6.2. The crux of the complaint is Parvati has been compensated for having lost her lands without the due process of law. She's my wife, Malas. However, in view of the fact that Parvati's constitutional right under 300A has been agreeing to 50, that's the crux of the matter. Then, Malas, it goes on. They say in 6.3, third line, entire allegations made by Abraham in his petition, even if admitted to be true, do not disclose any offense. So you can tell, the governor can say, disclose an offense for this reason. Doesn't deal with it. Then, Malas, next page 359. fourth line, 6.6. The fact of the matter is that pursuant to the alleged family arrangement between the brothers, Mallaraiya transferred the property to Venkatama. Therefore, the lands have come back to Swami, son of Mallaraiya, and thereby by way of deed of family arrangement recorded in so-and-so. All days are given. The first sentence says, Mr. Abraham is suppressing throughout. It gives all the facts. Then, 362, 6.8. The claim that possession was with MUDA is absolutely baseless since no possession notification or Amazar taking over possession is required has been drawn up. Then 364. This talk about, I'll not read all these facts. Document mark 364, 365. Then we also talk of further suppression in 366, in 6.24. We give the things which he has suppressed, the second part of para 6.24. It gives the suppression. And so on. Then come to 376. Then the law on sanction is fully dealt with. 380 tells your lordships sanction is necessary at the bottom of 380. I hope I'm clear, bottom of 380. Then 384 tells you that the stage for this sanction comes at cognizance, which is not the stage. That is 384.
Right.
I'm very grateful. I'm very grateful.
Yes.
Then 388 tells you the point I'm about to make, that it can be only by a police officer. 8.3. Now, these are reasons. What else the cabinet can do? It can give you every possible reason in law and fact. You deal with it. I'm not saying my main case is you are bound also constitutionally. Forget that for a minute. You're not bound. To still deal with it. Then, now come to what my Lord notes, 218. It is important, at 392. The Sanhita, which is 218, makes it amply clear that the said provision comes into play only at the stage of prosecution and taking cognizance of offences by a competent court of law. Furthermore, the nexus, etc. Then, 394 onwards, this exact judgment I have read to your lordship is cited. 394. And goes on till 397 with Yedurappa. Cited and quoted. My learned friend makes it sound as if I quote the law of the land, I am being frivolous or I am being too detailed. I am quoting the law of the land.
I have never said either of these two.
No. This is my adding color to your colorful expressions.
Yes.
Now,
I have no... I
now
don't have the privilege of using colorful expressions.
Now,
that's the privilege of a person, Dr. Singhvi, who is both in public life and professional life. I will have to... I can't use adjectives.
Anyway.
Yes.
The time being, I let it pass,
Let's not go on colors.
Yes.
Yes, Malad.
Now,
everything is black and white here.
That is correct.
Monochrome.
Right.
That is correct, Malad. That's the way it should fall from the judicial side of the organ, Malad. That's absolutely right. Your lordship is having that in the paperwork.
Yes.
Now, this antecedents, look at Malad, the habitual thing. I'm not saying you could dismiss the complaint of antecedents. Just see the para. We have dealt with it, 12.1. We've given facts. Mr. Abraham, history of criminal antecedent.
So, we have dealt with means what? You are chief minister.
No, this document which is before the governor has dealt with it.
We have dealt with it.
Yes.
Chief minister has not dealt with.
I hope the best. My learned friend has made two best arguments till now.
No, truth has a strange way of coming out.
The best arguments are, first is, I am the governor, give me time. Second is, that this document should not have the word we. I can't divorce myself from the fact that I am the chief minister, elected one of the state.
No, this is not...
This is a document of the sanction.
No, this is reply by the chief minister?
No. This is... I'm saying
cabinet decision.
Decision of the
I'm
cabinet.
saying, my learned friend is saying, well, just see the antecedents. Just see antecedents.
Yes.
Is it not relevant for the honorable governor to have seen this?
The word,
they pointed out that he was a habitual blackmailer and court bird with history. Supreme Court has strictured him. I've quoted that in terms of the document I'm reading. Not that I have drafted the document.
That may not be relevant for a decision.
Yes, that's all right.
Whether there is application of mind or not.
Now, this is very serious.
Yes.
The cabinet finds it to be selective Article 14 discriminatory arbitrary treatment by the governor. See that, para 13.3. That's a separate point by me. Just read this, very, very important one.
Yes.
The selective treatment of Abraham's petition, same day, given the governor's inaction on numerous other pending petitions, such as proposal for prior approval under 17A. Against normal, every detail is given. Shashikala Jolie, dated 2021. Supersonic speed same day versus 2021, 3 years ago. 3 years ago. The proposal dated 26th February 24, Murugesharani. That is 6 months ago. Janardhan Reddy. These facts strongly suggest that extraneous factors influence the governor's decision. The Supreme Court has emphasized that actions based on extraneous, etc., Bombay political vendetta. And then, Malas, the final advice is at 420. I would say, Malas, whether appropriate to one side or the other, the page number is appropriate. Now, this page number is also gone in the new sign.
No. That's what I was telling.
Now the page number is gone in the new sign.
The biggest change in, they said, no, there is no change. The biggest change is 420 is gone.
It's a psychological change.
Cheating is gone in BNS.
But Malas, may I say, 420 was never a section. 420 was a metaphor, always.
Yes, that metaphor is no longer in existence.
So, remember the very old Bollywood film in black and white?
Yes, Shri 420. That is also gone.
So, it was a metaphor, Malas. That metaphor will always remain, whether you have many signs. That's right.
But 420 goes away.
That's right.
Yes.
So, Malas, now the final order is, the Honorable Governor ought to have, under the present set of facts, acted only on the advice and aid, not in his discretion. While proceeding to issue show cause, failed to consider the material available, ought to have taken into consideration the reply submitted by Chief Secretary on 26/7, received by the Governor at 6:30. Chief Secretary inter alia highlighted the direction, constitution of Judicial Commission, etc. And then, Malas, all these reasons are given and finally said that you are obliged to. As far as I am concerned, I have separately filed a reply. I have not said that, look, I will not file reply because you are acting without jurisdiction, which you are. But without prejudice, I filed a reply, detailed reply. He has not considered that. Some of your lordships can add to the fact, he does not consider the cabinet's note, he does not consider my reply. Obviously, they will overlap in terms of content, in terms of substance. Now, let me come to so this is the one major point, in terms of the proposition. I go to the next one immediately. Is you, as the governor, are acting in a judicial reviewable capacity in granting or not granting approval, which my lord actually rightly and pithily summarizes as 17A/218. What you say is judicially reviewable on the standard classic grounds of relevant considerations, extraneous considerations, Wednesbury reasonableness, eschewing this thing or that thing, etc. Lordship knows that well. Forget that. My lord doesn't have to do that exercise. My humble and respectful submission is there is nothing. Your lordship read the order. Your lordship will do the exercise of Wednesbury reasonable after you see some reasons. The only sole reason is I am not bound by your advice. Hence, sanction or permission or approval. This is proposition 1 with the 2 judgments. The second is 17A, my lord read in the order. Now just note 2 or 3 things. Just take 17A. I'll just be very brief ones. 17A. I don't have to read any case law, though there are many. The section makes it clear. PC Act 17 capital A, as the lordship knows well, came in 2018. July 2018.
Yes, 26/7.
No police officer shall conduct, and it starts with that.
Yes.
No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant. So, alleged to have been committed by a public servant. Where the alleged offence is relatable to any... Now, just look at the... Are you not violating the legislative intent patently? Just give me a second. Put a full stop after the word act on the 3rd line. They limit, they don't put a full stop. They add a suffix. No police officer shall conduct, but additionally, even if he conducts, suppose if it's a non-police officer, the first condition goes, you can't do it. There is no police officer here as a complainant. Second condition is supra-added.
Not yet.
That's right.
Not yet a police officer.
Not yet. That's correct. No, we are talking of now the 17A stage, which is mentioned in the order. We are talking of that order. What will happen later is different. Now, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge, as my lord noted, of his official. Now, from 92 to 22, the file never came to me in any capacity. So, neither decision nor recommendation. What you are really confusing is with an alleged beneficiary to constitute, sir. So, you can't violate the section like that, on the face of it. You cannot violate the language of the section. Now, Please see. This is still granted. Despite that, there are 3 judgments of Lordship in note, Manoj. Sri Rupa, I believe it is
all are mine.
My Lord judgment.
All 3 you have cited are mine.
Well, I always am very hesitant to cite a case authored by the same judge before whom I am arguing. Well, I appeared many moons ago. I have told this to many people in Supreme Court, and my learned friend has heard it also.
I saw the index, and all 3 judgments are mine.
So I am grateful, Manoj. Your Lordship knows it well. Lordship will not have the citation. Give it to my learned friend, please. Kindly hand it over to him.
Yes.
I was telling Your Lordship the slight aside, which I have told my learned friend many times in Supreme Court also. I was arguing a matter before Justice Chinappa Reddy. And Justice Chinappa Reddy, Manoj, I came across 3 decades ago. I cited a case on all 4s in my favor. And it was authored by him as High Court, Andhra Pradesh judge. So after, he had a very twinkle in his eye and a sense of humor. So after 2 minutes, he says, but Dr. Singhvi did not realize that I was waiting for a chance to overrule myself. So I am sure Your Lordship is not waiting for that chance. Each of these 3 judgments, may I save time, it's not to be brushed aside.
It's an application of mind.
No, Your Lordship has given reasons.
Yes, I have reasons.
It can't be just ignored, Malas. I mean, I can understand there's a contrary division bench of Karnataka, there's a contrary Supreme Court. How can there be a contrary Supreme Court of what Your Lordship has written, Malas? With great respect.
I don't know if Supreme Court has written.
No, on this point, there can't be, Malas. What has Your Lordship said? My Lord has said that on 17A, the conditions precedent of the sections have to be, the mind has to be applied. Mind will be applied to what, Malas? To the condition precedent of the section, obviously. So this is not something which, Malas, it can be overruled. Your Lordship has applied the law. And all 3 judgments, Lordship remembers, Sri Rupa, Dr. Ashok V, and Praveen Kumar.
Yes.
3 judgments. Your Lordship has got the para, may I? Malas?
First one was Praveen Kumar.
Yes. Praveen is 14 to 16 para numbers. And Malas, the others are 23 to 28 is that Sri Rupa. But my Lord knows this. So you give the pages to him on the compilation. Otherwise, I don't want to.
Yes, sir, I'll go through it.
Now, note 2 more things, Balas, on 17. So, first point on 17A is conditions precedent of section. Number 2, Your Lordship's judgment. Number 3, there are 2 circulars about criminal law approach and investigation under 17A. One circular is by the High Court of Karnataka.
That is after judgment in JV Ashok.
I'm grateful.
Yes.
So, one is that, Balas, at 260 of the paper book. Just note that.
Given that,
and there is one by the central government, a SOP. 1 second.
Which is the central
First one is 260. Just for 15 seconds, just pause it that.
260.
Yes, that is 23rd September 2023.
Volume 2.
Huh? Volume 2.
Writ petition.
No, the writ petition. No, not the law, not the law compilation. The main writ petition file.
Page?
No, please. First is 260. I'm on the High Court of Karnataka circular.
260.
They emphasize it is mandatory. Please follow it strictly.
No, this is
That's
after
all.
Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document, which my learned friend was saying. On 3rd September 2021. 703.
Yes.
And the last 3 paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, if the condition because section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also. Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is 218. Can you turn to 218? What is the point here, Malas? At page 47, the learned governor grants, Malas, an order which invokes 218 of the Sanhita. At page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important for us, mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, Melis. You have to show what 218, what ingredient, what offense, how. How is important. See page 47. Lordship find nothing. Page 47 is nothing. It says exactly what I'm saying. 218. There may be other points I'm not arguing now on that point that 218 came now. This offense relates to when.
No, since...
but that's all right. I'm not... Your Lordship will have to see whether it applies back or not.
Sought after BNSS and being granted. It is only BNSS.
I am not even arguing that for the time being. Yes, I don't want to get into that. Now, there's two more things that I'm done. One is, the larger issue of selectivity of these 4 other complaints, which my Lord has noted that one page of the cabinet decision.
That I have seen. Let them all file their
names objections. Are given. Names are given there. Details are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the same day.
Let even the...
so, Manoj, I am saying...
SG is representing the governor.
My instructions are there are no sanctions pending.
Let me end. Yes. Let me just end. Please allow me to finish. One thing which is larger issue, not today, but Lordship should know the flavor of it. Just turn to 155 para number of Nabam Rebia. I'll be very brief.
155.
Para number. Now, I hope you get it correct this time.
Page
869.
Para 155.
Now, 155, that your Lordship's 1027.
Summarize our conclusions.
Right. Firstly, Constitution Bench is summarizing the measure of the discretionary power of the governor. So there's no point, my learned friend, just for us flushing it aside by saying, oh, it's a 10th schedule case. It's a 10th schedule case which arose in the context of an intersection with the governor. The governor tried to interfere. The court said, you stay put within 163.
Yeah.
Directly arose. So, my learned friends,
so here, sanction has to be accorded by the governor only.
Correct.
No,
we are not on the governor.
Found by the advice of the Council of Ministers.
Where
would not.
Where the chief minister is no party of the decision-making process.
That will consider.
That's yes. Now let's just see. Firstly, I think this point for a minute I'm assuming against myself. I'm just putting it because I opened with the other point.
Yes.
But I'm just putting it for 2 minutes and ending on that. The measure of the discretionary power of the governor is limited to the scope under 163(1). Now, 163(1) doesn't say that you can say blanket the entire cabinet is disabled because the chief minister is involved and he appointed you all. You can't say that. That's too general. Then, Malas, all the cases your Lordship has of conflict of interest are where I'm in some way directly myself deciding my case. It's not this case. Then, Malas, secondly, under 163, the discretionary power extends to situations where a constitutional provision expressly requires the governor to act in his own discretion. Expressly. None. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provisions concerned, and the same cannot be construed otherwise. Fourthly, in situations where this court is declared, sometimes a Lordship says you shall decide. That is not this case. And lastly, Malas, fifthly, or 163(2), final and beyond the scope of judicial review, answer no. Answer no. Now, Malas, 2 things I've done here. I have read to your Lordship the last word of a Constitution bench. I have read to your Lordship 163, which is directly relevant to the governor's powers on the larger issue, not argument. Just one thing and I end, Malas. Just to tell your Lordship why my infants, instructions are wrong on this. Note this, that MP police judgment which is in your Lordship's file at page.
Yes.
Just note these paras. This Lordship may note because it will be difficult to find out. Yes.
No, 262.
But just note these paras.
Yes, that's all right.
No, I'm sorry. My apologies. I meant something else. The paras of Navam Rebia, which deal with MP establishment, those paras.
Which is that?
Para 116. Lordship will note the paras. Lordship will see it later on because it's not being argued now.
Yes.
So clearly, Navam Rebia will govern, not MP. The governor cites only MP. Now see those paras. 116, 118, and 118 may be ticked by our lordships in particular. I'm emphasizing it. 128.
See, this is exactly the point. There was a case where governor had to act or was required to act on the aid and advice of the Council of Ministers because he is not acting on his own. Now, here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say.
Very well, I will.
According this judgment may not be.
No, therefore I'm saying, I'm only saying Nabam Rebia and MP will be considered at final hearing in some form as to how much of MP remains. That's all I'm saying. I'm not. Let me not argue it now.
Because what was imperative in there and imperativeness here are totally different.
Now,
the role of the governor.
I bow down to that.
Yes.
Well, lastly, two things. First and foremost, the governor is a person who has spoken in his order. If I don't make him a formal party, we make even tribunals a party frequently. But they don't necessarily, he cannot have an interest in your lordship granting me or not granting me interim protection.
That will.
No, I'm just pointing out, yes. Because it's easy that I'm a governor, I've come, therefore give me. I'm saying he may be there. He may come and deal with it. But he can't be personally interested in expanding, rewriting or supporting his order beyond the interim stay which one is seeking today. Number one. Number two, and it would be very odd for a governor to do that. It will validate my point. Number two, it is clear that the matter is before the court tomorrow. Now, you will have cognizance, you will have pre-cognizance and post-cognizance actions. The whole idea is to then start a process to undermine and destabilize the government. Number three, it is also constitutional law, law and politics are intertwined. We are not, we don't live in some ivory tower, cloud cuckoo land. Your lordship is not in a, that storm is coming, so I'm a ostrich, so I put my head in the sand. That's not the way judges function. So immediately then, a whole process starts clamoring. There is, of course, nothing in law short of a conviction which affects your resignation. But the idea is, why start a process which is on the face of it, 1992, 2024, today you go to the governor same day issues show cause. Within 2 weeks, we are less than, let's say, 1 month. And he must, your lordship, on what balance of convenience must there not be a status quo ante as of prior to the order of the governor's order? On what basis? If heavens have not fallen from then to now, and on what basis will the one day before the order of the governor not be a valid balancing of equities, not be a valid irreversible consequence test, not be a valid balance of convenience test? And governor, just because of stature, should in fact keep away more aloof. He should not be saying, why no stay?
Anybody has to reply, we'll see.
Only 5 minutes, Manoj, because I have yet to go through it, Manoj, but I have
go through the papers, file your objections.
Manoj,
who are respondents, let them come up with objections.
Yes, certainly, Manoj. Only few facts, Manoj.
Yes.
Without going into the merits, Manoj, because my learned friend said something, and we have an answer, Manoj, in law of everything, Manoj. I represent the governor, the office of the governor, and therefore, Manoj, I do not have the luxury of using adjectives like friendly governor, etc., because it would not be in good taste. Suppose I also start saying subservient cabinet or a corrupt chief minister, doesn't look good because all are constitutional functionaries, and irrespective of the party position in the petition, whether we are petitioner or respondent, we must respect the constitutional office. The three questions, which I'll have to answer, first would be the power of the governor in granting sanction under 17A vis-a-vis the cabinet decision. I'll be able to show para to para, page to page, cabinet decision and the pages of the petition, verbatim saying, if cabinet decision is first, then it's okay. Then, my lord, the person who has drafted the petition is guilty of plagiarism. But if the draftsman is same, then the cabinet is guilty of non-application of mine. But that's, my lord, on facts. In law, MP, my lord, governs the field, and MP judgment, my lord, clearly only, my lord, one paragraph, if your lordship permits me to cite, my lord, concludes the issue, my lord, so far as the constitutional position is concerned. My lord, please come to, my lord, that MP judgment. I don't have, my lord, my learned friend's compilation, but MP judgment, para 14.
I've not even argued for time being, but I've not even argued. I started, I left it there.
Para 14. Mr.
Yes.
Dr. Singhvi, you argued for 2 hours. Give me a few minutes.
Yes, sir.
I'll confine to the constitution and not any spicy expressions for media. But please see para 14.
Yes, sir.
As has been mentioned above, your lordship gets, Manoj?
In
Lord, MP Special Police Establishment versus State of
that's
MP.
225.
Yes, Manoj, it's a constitution bench judgment where precise question was the power or responsibility of the governor while granting sanction, whether he is bound by the cabinet decision or not, whether aid and advice of the cabinet would be binding on the governor or not. Para 14 starts, my lord. I am not reading the entire judgment at this stage. My lord, I'll assist your lordship, my lord.
Yes.
But your lordship may not find that judgment.
Lord, 14, my lord.
Where do I?
Copy, you can give a copy. My learned friend is giving a copy.
14 and 19, my lord, 2 paragraphs. My lord, that summarizes the law. And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord?
Yes, I'm there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. Principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now, please come to, my lord, 19. They are saying
Yes,
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Para 19, my lord.
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc., my lord. There was material before him, prima facie, etc. My lord, the second question, which I'll deal with, my lord, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet notes. My lord, there are twofold answers. My lord, answer on facts. My lord, the the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will go into the matter. I'm sorry. Go into the merits of the case. Your Lordship's judgments on only police can seek approval and not that helps, that assists your Lordships again, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record. And whatever, constitutional position, I'll assist your Lordships.
All right.
I would request, any date, because once, the governor, who is a constitutional functionary, has granted sanction, injunction of any kind, whether direct or indirect, by another constitutional body may be avoided. That's all.
The submission we have to hear and readings have to get complete. The submission is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
Unfortunately, in our legal system, nothing happens in a day in a court of law. My learned friend can
act on the sanction. They can't act.
Yeah, because indirectly also, the Lordships
will post it day after tomorrow or Thursday, whichever day you want.
Thursday.
We'll post it Thursday. Day after. Let not the court proceed further till Thursday.
They can seek time. There are ways and ways, doctor.
Let it not.
No, the complainants are here, but the complainants are here.
Complainants are here.
Lordships deferring staying the proceedings.
I'm not granting anything of that kind. Wait.
This is not an ego fight. Your Lordship is only saying not till Thursday. It's not that we have
to... it's not an ego fight. The question of
my learned friend is not going to be part of the proceedings there.
No, I am not going to be.
No,
I understand. I understand, Dr. Singhvi.
Yes, sir.
1992 to 22 proceedings in
Thursday.
That
everything I will answer. That's a different thing. SG, sir, I just wanted... See, day after tomorrow, if the proceeding is there and he would proceed to pass some order, then these proceedings should not... They may not become...
infructuous.
I bow down. I'm for a second not, my lord, either supporting or opposing, my lord, the state, because it's for the complainant to do. But
no, because we are hearing the matter, hearing is whole house.
Certainly. But I have a suggestion to make. Lord, the governor having granted
whatever matter is tomorrow.
Lord, governor having granted sanction tomorrow. Any ma'am, please always.
1 minute, yes.
Ma'am, if you don't mind.
Well, I don't understand why the SG is arguing on the interim stays.
No, I'm not arguing on the
interim. No, he fairly said that he's neither against nor for.
I'm neither against nor.
That sentiment is maintained.
Lord,
that's not
principally, constitutionally, once the governor's sanction under challenge, based upon which some proceedings are on, another constitutional body, namely the court, would be very wary. I'm not saying there is no jurisdiction.
Well, the High
Court, anything. Only a minute, Dr. Singhvi now. Dr. Singhvi, please. For me, it is only a matter, not even a professional matter. My lord, instead of your lordship saying, let the complainant say that both can seek time, my lord, and there is that can be taken care of.
I will appropriately balance it.
That's all, my lord, I am suggesting, my lord. We are before your lordships and we would not do, but I would not like anyone to do anything
which is listed tomorrow before the special court. Lord, section 17A, my lord, which came to be inserted in the month of July 2018. The offences alleged are right from the year 1998, my lord. There are sequence of events which are described. Now, my lord, whether section 17A would apply to the crimes alleged to have been committed. Before, my lord, the insertion of section 17A is to be looked into. So, therefore, the instant proceedings, my lord, would not, my lord, affect the proceedings before the special
court. So, the decision is not required, is it?
No.
Whether it would apply or not?
Submission is that.
Now,
my lord, tomorrow's proceedings, my lord, I mean, much reference is made to the proceedings before the special court. Finally, my lord, no orders, my lord, in connection to the proceedings before the special court, pursuant to the PCR, my lord, can be passed. Because the same is not in question before this honorable court. It's only the validity of the sanction order that is under question.
No. The consequence is what the learned senior counsel is saying. Try to understand. A superior court now is holding these proceedings with regard to questions to be answered by this point or by this court.
Absolutely.
Now, at that point in time, some proceedings are taken up there, which would frustrate these proceedings, not fair compli. Frustrate these proceedings will not be correct.
If at all, my lord, if at all, the petition, my lord, succeeds in the instant petition.
All right.
Then, my lord, even then, the Sadak series case, my lord, which is clearly on the point that when there is fabrication of documents alleged.
Against whom?
Against all the accused persons, my lord, against the accused number 1 to 5. When there is fabrication of documents alleged, certainly, my lord, the question of sanction does not arise at all. I'm not complying with my lord's judgment in Dr. Ashok's case. I had, my lord, as a procedural formality, I had applied to the governor. The same, my lord, does not mean that I accept the proposition that only with the aid of sanction under section 17A, I must approach the special court. Because in the instant case, the alleged offences are much prior to the date of insertion of section 17A into the Prevention of Corruption Act. Therefore, in the Sadak series case, very clearly, my lord, Justice Oka's headed the judgment. The judgment rendered by the bench headed by Justice Oka is clear on the point, which clearly states that when there is fabrication of documents, it is nobody's discharge of official duty. It cannot be considered as discharge of official duty. And even section 17A, my lord, it clearly reads at the end of the definition, my lord, which my lords may kindly peruse.
There is fabrication against the chief minister also?
But there is
direct question, direct answer to a direct question.
Whenever section 120B is, my lord, alleged.
Conspiracy.
Please, there is conspiracy.
Conspiracy.
Please, absolutely.
Yes.
When there is conspiracy, my lord, it cannot be said that it can be
That
individualized.
we'll see.
The act of one is the act of all.
That will see.
When there is 120.
Oh, don't say all for one and one for all here.
Please, my lord. Section 17A, my lord, if my lordship may kindly peruse.
That I have seen, sir.
Please. Now, no police officer shall.
All right.
My lord, here.
That is after registration of crimes.
Absolutely, my lord. Now, since section 17A sanction is obtained, it would, my lord, facilitate the special judge, if at all, if he so comes to a conclusion that the matter deserves referral to the police officer.
You file your objections.
Absolutely. Please.
Yes, now
I appear for the...
Respond number 4.
I appear for the respond number 5. Only on the question of interim order, I thought I must bring to lordship's notice. Hello, sir, 1 minute, I'll just cover it. 1 minute. On the question of interim order, section 17A, but on an earlier occasion, this situation came across where the sanction was challenged. This court, division bench has taken the view that there cannot be an interim order of stay insofar as under the Prevention of Corruption. But let me point out that. Okay. If lordships are to, this is the division bench order, which is what later on has been referred to.
No, this is why Justice Mukherjee or order Dadmel again.
But subsequent, kindly see at the stage of interim order, how is that the lordships dealt with it. First page is the prayer. First, may I now request lordships to kindly see internal page 9. Internal page 9. Indeed, insofar as the grant of interim prayer is concerned, it is no doubt true that interim prayer which is sought for the writ petition is sweeping in as much as it seeks suspension of all proceedings pending disposal of the writ petition. Indeed, the question would be whether such a request can be granted. In these regards, certain provisions of the Prevention of Corruption Act 88 is required to be looked into. Section 19 of the Act would speak about the previous sanction to be granted for prosecution with respect to public servants. Subsection 1, their lordships refer to subsection 2, subsection 3. One second. But kindly see in internal page 10, second paragraph. Indeed, we have not this. Indeed, we have not reached the stage of subsection 3C of the Act. Insofar as subclause B of section 13 is concerned, we have also not reached that stage. We are yet to see whether there is any error, omission, or irregularity in granting the sanction, which has occasioned the failure of justice. This is a question which is required to be thrashed out when the matter is heard finally.
Yes, I have seen.
Then what their lordships refer to Satyanarayan Sharma and say 19(3) prohibits the court from considering grant of interim stay. But Satyanarayan Sharma says it also applies to the High Court.
There was sanction under section 19.
No, that's true.
Stage was after investigation and a final report being ready.
I request now lordships to kindly see section 19 once again.
19, we have not yet reached that stage.
No, the subsection 3 applies to all proceedings under that. That's what I want to
all proceedings under the Act, qua section 19. We are at the threshold on 17.
I request lordships to kindly see 19 for a moment. 19 yes. Subsection 3. Subclause C. Notwithstanding, lordships get it.
Yes, I'm there.
Notwithstanding anything contained in the Code of Criminal Procedure, C, lordships may kindly see and kindly see the emphasis. No court shall stay the proceedings under this Act. But it's not Core 19. No,
even this court?
Look, the Satyanarayan Sharma, this is exact Satyana. But now kindly go back to the judgment.
Yes, sir.
This very question was as to whether this would also apply to the High Court. And Lord Satyanarayan Sharma says at internal page 11, may I request? Internal page 11, may I? But however, there is a clear embargo on stay of the further proceedings. Indeed, the decision of the Apex Court in the case of Satyanarayan Sharma, reported in year so and so, wherein a similar, if not identical question fell for consideration. And the Apex Court was of the view that when a sanction is sought to be questioned elsewhere, the question of suspending the proceedings would not arise. The Apex Court has observed as, and then what the lordships refer to 482 itself. Thus, in cases under the PCA Act, there can be no stay of trials. We clarify that we are not saying that the proceedings under 482 CRPC cannot be adopted. In appropriate cases, proceedings under 482 Criminal Procedure Code is entertained. There can be no stay of trials under the Act. It is then for the party to convince the concerned court to expedite the hearing of that. This principle.
Principle true, sir.
Yes.
There can be no qualm about the principle at all. Those were cases where investigation was complete, sanction was sought for prosecution. We are at the threshold.
No,
we are at the threshold where 17A is being debated upon.
I want to address your lordship.
That's the only thing.
I wanted to submit.
See, it is like this. Now today, this court is hearing the matter. The other court, pursuant to the sanction, passes some order which would frustrate the proceedings before this court. I, for one, will not permit.
No, for a moment, I'm not suggesting that.
Yes.
For a moment, I'm not suggesting that proceedings should result in a fait accompli to this petition.
No, it won't result in fait accompli. This court, power of this court cannot, it should not frustrate the proceedings even.
In fact, they have raised certain questions of law.
We
will address it.
We'll answer.
You will file a detailed counter.
Yes, you file a detailed counter, will answer all the questions.
All these questions.
It's a question that requires answer.
Kindly keep in mind that there cannot be per se stay of all further proceedings. This is what I'm
we will answer all that.
Insofar as the questions of law which have been raised are concerned, we will certainly answer all of them.
Yes.
I think complainants can consider requesting adjournment, my lord. Complainant can.
Insofar as I am concerned, I must bring to lordship's notice. Respondent number 5 is concerned. I have not initiated any proceedings pursuant to the sanction which has been granted under 17A.
One very important fact got left out. It is for orders tomorrow in one of the complaints. Tomorrow it's for orders is what we are not called because we've learned from the press and everywhere. That will decide cognizance taken, refer to Lokayuk, whatever the order will come, then we'll come and say amend the matter, go and appeal. I don't understand if the High Court is seized of the matter and I have moved in 3 days, it can be reversed. I can vacate everything. For orders, they should have told you. They should have told you. That's right. So, once the order is passed.
So, it touches upon the sanction.
Directly.
No, at that point of time when the complaint was filed, apparently, there was no sanction. This is a subsequent.
This is
I think if the complainant seek time, everything would be sorted.
Sir, 218 it was always there.
Please.
In the statute book. Or 197.
There is no retrospective operation of...
That is true. That's settled principle, sir. Madam, yes.
Distinction between no sanction and invalidity of a sanction. Lordship Supreme Court very clear on this aspect that if there is no sanction, then on that issue that they could raise.
This is not a case of no sanction at all.
This is the case of invalidity of the sanction, and that
Let
can
me see.
be a matter for trial. So at this stage, Your Lordship, to you.
We are not on that. We are, the learned senior counsel has projected few points with regard to the validity of the order of sanction of the governor. Yes.
If there is already a
No sanction is a different footing.
whether it's biased, whatever it is, it would be a matter of trial.
Who the concerned court will decide whether governor's sanction.
Special judge will, yes.
Special judge will decide the validity of the governor's sanction.
Might have
Lord, I think the complainant can seek time tomorrow, my lord. That would.
No, you think, madam, you're seriously saying this, that the district
cannot
judge,
decide, my lord. I am
Court
objecting
of
to
Session
that.
will decide on the validity of the governor's sanction.
Not such an extreme proposition, but it can't.
My lord, I am also not supporting that.
Whether
extreme
governor has
proposition.
applied his mind and while passing granting the order of sanction is to be decided by the
Lord,
concerned court or by a
cannot
constitutional
be
court.
done. It can be done only by your lordships, my lord. I am also
It is
not
only by a
supporting.
constitutional court, not by the Court of Session.
Then it's a matter for 3 days.
My lord, learned AG may not, my lord. I am at least the author of the judgment. He is no one, my lord.
Just 3 days, not 3 weeks.
File your objections.
That's all, Manoj. Why should the governor at all speak for the complainants at all?
He is not, sir.
No, it is a suggestion to the lawyer.
Everybody should agree for 3 days before. Where can we run away, Manoj?
I will,
If the complainants can seek
agreed or
agree
not,
to seek
I will pass
time,
some order now. Yes.
Very well. Your Lordship,
Lord,
I have
if the
enough.
complainant can agree to seek time, it can be
Length of the
sorted.
order or the time taken to pass the order, my lord, cannot be a parameter, my lord, to decide
What length of-
validity.
Am I deciding that now?
Because that was
No, sir.
My lord, I can't.
that was quoted, my lord, by the other.
Don't worry about that. Yes.
Anyway.
Your retrospectivity, all
Mr.
other things will
Nawadgi,
not
if
serve.
your client and others can agree for an adjournment,
Sir,
Later, it was referred to a larger bench. But as of now,
that is referred to a larger bench, that I know.
That requires all consideration.
Yes.
Only one request, subject to.
Matta.
No, not for them. But instead of Thursday, if it can be Monday, subject to the convenience
next
of
Monday.
all others.
Mr. Nawadgi, I would personally request you. This is something that requires my physical presence.
Monday, the
Allow me to
Yes,
be there on
holiday.
Thursday. Because I'm asking a shorter date, not a longer date. He's asking a longer date on my behalf.
Mr. Nawadgi, Mr. Nawadgi,
Require some
No,
time for
Thursday.
We'll do it this way, sir.
Yeah.
I'll have it on
Then
Friday.
serve a
I'll-
copy in advance and all.
1 minute, sir. If all of you
can
talk
I
about, where
request?
can I
Can I
talk?
make a request? Can I make
What
a
is this? Yes.
Can I make a request, my lord? If Mr. Nawadgi and other complainants can say that we'll seek an adjournment, Lord, that would solve the problem.
No, till Friday, I will
I have it
to
on
list
Monday.
this on Friday. By Friday, let the pleadings complete. We will hear it whole hog and
On
answer.
Monday.
Monday?
You should be saying on Monday or?
Friday, sir. You said Monday you don't have.
No. I said it was
Monday is
Thursday.
not-
If not Monday, my learned friend is saying,
No, this Friday you're not free.
does your Lordship sit on this Monday, Manoj?
No, Monday it's a holiday here.
Then Thursday, Manoj. Have it on Thursday. Friday will be a problem.
This Thursday.
This Thursday.
3
That is
days.
Monday before Friday.
Not what happens Thursday is
Next
we'll have to
Thursday.
prepare a counter server upon.
But I'm only asking for.
I'm only
Sir,
saying.
I'm asking
just-
for a 1 day in advance. Otherwise, have it next week. Give me next. This is a problem with you here. It's a big problem with you. What are you saying this for? What is all this nonsense you're saying this for? What? No, they will not
Apex
take it
Group.
that long. But just give me a minute. I need to see your dates. Really gone case here.
Yes. We will.
You should have got
Anything
it
else, madam?
Next week.
Mr. Nawadgi, am I audible to you at least?
Yes, please.
Yes.
If I can
you as
request
well.
my friends to seek adjournment on before the court,
I
We'll
don't
do that.
understand why the governor
I will-
wants adjournment. Well,
We'll pass some orders.
then can it be this following week? Well,
No, that's all that I'm saying is not only.
Or
all right.
so let
Or
it be Thursday.
Next
Manoj,
week,
let it be
29th.
Thursday.
Next week, Manoj, the following
Well,
week.
let it be
29th is fine.
Thursday.
But
29th.
29th will close it.
Yes. We'll all come,
So I have
come
a-
here, Manoj, physically, and we will be here full arguments.
So I have one request. Now, Lordships notes are in session of the matter, but we will file our counter.
Yes.
We have not actually addressed arguments on this.
True.
All that I'm requesting. We will seek, I'll request them. We will seek deferment of the proceedings. For any reason it doesn't do so, but they are always at liberty to move your lords.
You
Lordship
cannot
may
seek
direct
deferment of
deferment of the-
orders.
I'm only making
cannot
request.
seek deferment of
I'm
orders.
making a request. No, it's not a submission.
29th is.
Well, it's
My lord, may I suggest, your lordships may say, let the proceedings
29th.
order, if any, be deferred.
Well, this is not. Why should one have so many political overtones? Lord, she's putting in next week
There are
for
no
final hearing on
political overtones,
29th.
Now,
Dr.
if
Singhvi.
all of you
None
permit
of
me,
us are in
29th,
politics.
fellows, and the matters for orders, we can't defer it by consent. We can't
I
defer
will
it.
pass some order. Yes, sir.
My lord, let it be Thursday only, my lord, this Thursday.
No,
29th.
No,
others are
29th,
saying they'll
doctor.
complete the pleadings by 29th.
It takes time to complete. It's only 5 days after that.
I have no difficulty, but I may remind Dr. Singhvi, 28th is Vijay Madanlal's review.
That's all
29th.
right. It won't happen for so long. It's
It
been
won't happen.
called out so many times and adjourned many times, and we'll adjust. I mean,
Yes,
this has to adjust
Dr.
it.
Singhvi, I don't wish to controvert you. It was
That's
listed
the
only
previous
last
day.
time.
Don't block the next day for it now. You have got the
No,
previous days.
I mean,
Let us kindly have it on
actually, Dr. Singhvi, it can be on 29th. I have no difficulty.
kindly agree
Let
then.
us be correct on facts. We are before the court of law.
That's all
It's
right.
not called out several times. It is listed only once.
Very well.
last
I may
time.
be wrong. I'm only requesting for 29th and your
Yes,
cooperation for
kindly
29th.
admit it.
That's all.
Let's not
Very
mislead. That's
Very
all.
well.
Yes.
But the difficulty is, my lord, Dr. Singhvi has many people, my lord, there on the other side in that review. I am the only one, my lord. That's
What do
why.
I have? The army opposing me there.
No, Ms. Dr. Sibbal will lead him. Thereafter, the
Now,
other counsels and then he will
Let my
follow.
laws dictate. Let my laws
we'll take this on the 29th, sir.
Please.
We'll take this on 29th
13.
at 2:30
Any
p.m.
date, my lord,
and close
it's
it.
for the complainant to decide. It's not,
Yes.
my lord, my choice. My lord, let
Yes,
it be
yes.
a week next. I have no difficulty.
It's just a week, sir. Yes.
No, I have no difficulty, even if it is
Yes.
month. It's for the complainant to, my lord, say this.
Yes, sir. The Chief Minister of the state of Karnataka is before this court calling in question a communication dated 17/8/2024 by the office of His Excellency the Governor, appending to it an order of the Governor granting approval under Section 17A of the Prevention of Corruption Act and Section 218 of the BNSS, which is 197 of the CRPC. The learned senior counsel, Abhishek Manu Singhvi, appearing for the petitioner, the learned Advocate General, learned Solicitor General of India representing the Governor of Karnataka, the learned Advocate General for the state of Karnataka, Counsel R3 Garu, Abraham, Counsel Ranganath representing Abraham, third respondent, the Shri Prabhulinga Navadgi representing the fourth respondent, fifth respondent, fourth Niva, sir, learned senior senior counsel, Allah senior counsel, and learned senior counsel, the Prabhulinga Navadgi representing the fourth or fifth respondent. The learned senior counsel appearing for the petitioner, taking this court through the documents appended to the petition, pointing at several paragraphs of the order of the Governor, which accords sanction for, which accords approval under Section 17A and sanction under 218 of the BNSS, to prima facie demonstrate that the order of the Governor bears no application of mind. He has projected several grounds with regard to the order being passed in a breakneck speed as the complaint is registered, complaint is placed before the Governor on 26/7/2024, and on the same day a show cause notice is issued to the Chief Minister as sanction was sought for prosecuting the Chief Minister, and the non-application of mind insofar as a detailed order that is passed by the detailed deliberations and proceedings that are passed by the cabinet while declining, while answering a answering, that was a show cause notice, is it, to the cabinet, while answering a show cause notice placed before the cabinet. The learned senior counsel.
I also answered separately.
Yes, yes. Learned senior counsel would further submit that the chief minister also has has replied to the show cause notice separately. He would quote other instances where the complaints, where such sanctions are being sought before the governor on several other political functionaries are kept lying, and the present complaint is picked and chosen for grant of sanction, which is grant of sanction. The learned senior counsel, the learned Solicitor General of India, representing the governor, would submit that no application is pending as on today before on the table of the governor for sanction, for awaiting sanction. The learned the learned Solicitor General would submit that he would place everything on record, and the notings in the file where the decision is taken to prosecute the permission to prosecute the chief minister.
Sanction.
Approval and sanction to prosecute the chief minister.
So, to investigate, my lord. There is a distinction.
218 is sanction.
Yes, ma'am. No, sanction to investigate. Prosecution
section 218 is sanction to prosecute.
Direct 197.
That is 197 of CRPC. 17A is investigate. The order passed is the 2, that's why. Yes. So and so. The learned Solicitor General would submit that it is only permission to investigate the offence, and no order interdicting the grant of sanction to investigate or to prosecute should be granted at the hands of this court. The learned senior counsel, Prabhuling Navadgi, would also join issue to contend that there should be no interdiction or injunction granted to the order of sanction passed by the governor to prosecute or investigate the complaint against the chief minister. The learned senior counsel KG Raghavan and the other counsel so and so would also toe the lines of the learned counsel Sri Prabhuling Navadgi, or the toe the lines of Sri Prabhuling Navadgi in contending that there should be no injunction to the order of sanction, that order of sanction to prosecute, order of sanction to investigate or prosecute, as the case would be, at the hands of prosecuted by the governor. The bestowing prima facie, bestowing serious. I have bestowed my anxious consideration, albeit prima facie, to these prima facie submissions that are made by the respective learned senior counsel representing the petitioners. The learned senior counsel for the petitioner submits, and the others would admit, that the matter before the concerned court is for its orders on whether a complaint would be entertained in the teeth of there being no sanction being accorded for prosecution of the chief minister. If those are the order, if that is the order that is kept to be pronounced tomorrow by the concerned court, and now the sanction is granted and the sanction is now being challenged before this court, it would any order permitting any action of the concerned court in proceeding further would undoubtedly frustrate the proceedings pending before the court, though it does not render the proceedings before this court a fait accompli. Despite the vehement opposition of all the learned counsels appearing for the respondents that there should be no injunction granted to the order of the governor.
Complainants, my lord, I was not vehement on that ground. It's a constitutional issue. Vehement by the complainant.
Except though the senior counsels appearing for the respondents 3, 4, and 5, to since the matter is being heard by this court, and the pleadings are yet to get complete till the next date of hearing, the concerned court shall defer its proceedings.
Dusty.
Huh?
Take it Dusty, it's tomorrow, so we just...
The direct service, my lord.
Dusty.
That I will do.
Dusty,
That
because just my learned friend was just saying.
all of them are here, I guess.
No, that is no problem. I don't doubt my learned friends. But it's a court for orders.
No, this I will get it uploaded.
That's all.
That's
all. I'm very deeply obliged. 29th, fellas.
I have no injunction granted.
Really grateful.
For all that, I'm one more line. One more sentence.
My lord, on the lighter side, Dr. Singhvi would agree with me on 28th to get the review adjourned before the Supreme Court.
It's very unfair, fellas. He opposes me there, he opposes me here, he wants to oppose me everywhere.
No,
Or will say not to precipitate the matter.
Choose one forum.
This is fine.
Defer the proceedings and not precipitate the matter till the next date of hearing.
Please.
Well, there is another...
ಅದು ಹೇಳಿದ್ದು.
No. You ask for...
ಅಲ್ಲ, ಆರ್ ಅಂತ ಹೇಳಿದ್ದು. Till the next date. So.
Kindly notices may be ordered.
Well, there is a technicality. There's a small technicality. I mean, it's the substance and the spirit of a lordship's order is clear. There are proceedings, well, it's before investigating officers, police station.
No,
other complainant is coming for further hearing day after.
Where?
So same court, but this tomorrow is one complainant.
No,
the fellow is coming. So
yeah.
no coercive action was on the basis of this order is all that.
Nobody, your police will not take coercive action against you.
No precipitate action on the basis of
this. I think
coercive action against chief.
No, I'm sorry, my lord. I'm sorry. I'm opposing that.
It can't be that tomorrow it is said, next day the other complainant comes and says that something is done Tuesday.
I'm sorry, other complainant. We can't argue on speculative
connected to this.
Tomorrow there is tomorrow for orders. Day after, the other complainant is for further hearing.
No, all proceedings.
All
proceedings concerning this issue.
It's not even prayer. There's not prayer.
Very well. All proceedings.
Sanction.
All proceedings.
It may be confined.
No, all proceedings of...
What is challenge is sanction only, sir.
Subject matter of petition.
Yes,
obviously.
Very well. Your lordship said all.
So,
that's all.
Now, the matter is being heard. Now, matter is being heard. You also should not precipitate the matter.
No, absolutely
It is not gainsay in saying when matter is being heard in the High Court, I will go into whatever I want.
The apprehension note exhibited by the learned senior counsel was the matters are pending before the courts. Therefore, if not the matter, if for any reason it is to be adjourned and without there is likelihood of a prejudicial order by the court below. It is for that reason lordships are now saying.
Pass the order now.
I am not opposing.
I have said
just saying
all
court will defer the proceedings and not precipitate the matter in any way.
Very well.
That is all I have said.
What are
the other
subject matter of the petition?
There is no other proceedings.
Yes, what the subject matter of?
Or whatever complaints on. No. See, I'll tell you one. Before I answer anything, this I'm answering one complaint or whatever. The other two complaints should not rake up and then go and proceed.
No. That's not the idea. That's not the idea.
We will defer that.
Don't touch that part of the order. Is okay. My lord asks a separate question. What else is there? My learned friend instructs me. There are complaints filed at different authorities. Obviously, your lordship's word between us understands no precipitate action.
That is not before me.
No precipitate action on the same sanction.
Yes.
Same, that's all.
Pursuant to sanction, no precipitative action.
That's all. That's
Chief
all I want.
Minister afraid that
That's
the
all I
PI
want,
will
Police.
go and arrest him? Is the Chief Minister afraid that a PI will go and arrest him? What are you
Pursuant to the sanction.
For the sake
One minute, sir. 1 minute.
For the sake of it, don't pray.
1 minute. Sanction is qua respondents 3, 4 and 5.
Yes.
Understood. We will answer it. Complaints pertaining to others is not before the court. That is not you are seeking that also?
No, Malaj, I am saying precipitate action pursuant to the sanction be not taken. That's all I am saying.
No, that means
all I'm saying.
in RAM.
That should be correct. What is the problem in that?
What is seeking for? That is what we are seeking for.
Kindly clarify that.
I think this takes care of it.
Precipitate action. The
sanction.
Impugned sanction.
Obliged.
Yes.
That's all.
Highly grateful.
Very deeply obliged.
Lord, notices may be ordered.
Thirdly, one notices yarik.
Because I'm not the caveator, my lord. I have not filed caveat.
Whoever is to accept notice. One
Respondent number 3.
learned.
We'll give everybody else here.
ಬರ್ದಿದೆ ಏನ್ ಬರ್ದಿದೆ ಮೇಲೆ ಬರದು ಅಲ್ವಾ I have already ordered in the beginning itself. Yes.
Very deeply obliged.
We will keep it on 29th at 2:30 p.m.
Very deeply.
Yes.
Not prosecuted ಅಲ್ಲ ಏನು ಆದೇಶ ಮಾಡಬೇಕು
I just take the page.